Good evening, everyone. For those of you that don't know me, I'm Jo Bragg. I'm the Chief Executive Officer and Solicitor at Environmental Defenders Queensland. This evening I'd like to start by acknowledging the traditional owners of the land on which we meet and their elders past and present. I'd also like to welcome members of the judiciary who are in attendance today. Councillor Helen Abrahams, who I think is our sole elected representative attending today. I'd like to welcome fellow legal practitioners, and I'd also very much like to welcome Environmental Defenders Queensland supporters and volunteers. There's a number of you here today. A special welcome to community litigants. I can see a number of faces in the audience of people who have, as part of groups or individually, decided to stand up for the public interest in various Queensland and federal courts. So a special welcome to our community litigants. For those of you not familiar with Environmental Defenders Office, our mission is empowering the community to use the law and protect our environment. So we're a community legal centre, public interest focused, non-profit, and out there trying to help people with access to justice to protect the environment. So in particular, like all community legal centres, we provide legal advice through our evening advice line, free of charge. We run public interest litigation on some occasions, and we're very active in law reform and public education. So as a quick example, today I met with Minister Lynham to put forward the policy view that community appeal rights in relation to water licences for major mines should not be removed from our Water Act. And in relation to education, we've run a series of law jams or evening events on different environmental legal topics, of which this is one. In terms of court cases, I'm sure you're aware of some of the legal challenges mounted by community groups with assistance from EDO Queensland in relation to mines, in relation to the reef, and many planning matters and biodiversity matters. So I was asked to say a little bit about costs, and I think the easiest way to do that swiftly before we get on to the main speakers is just to remind everyone of what are the 5 elements of public interest litigation. So to run a successful item of public interest litigation, at EDO Queensland, our solicitors have a bit of a checklist. Naturally, you need a client. We don't bring these cases of our own volition. In every case, we represent a client, usually a community group or a conservation group. In many cases, lately, it's been rural groups. That client needs, under the law, legal standing to argue an issue on the merits or to argue that the law should be enforced or complied with. Usually, the community client will not go forward unless there's suitable cost rules. Usually, each pay your own costs unless it's frivolous or vexatious, or otherwise cost rules that don't stymie public interest litigation. EDO Queensland won't run the case unless there's a very strong public interest and environmental element in it. With little resources, it's very important that we stick to cases that set an important precedent or stand up for our world heritage, our wildlife, or some other really important element of access to justice under our environmental legal system. You can't run the case without resources. That includes solicitors at EDO, but it also includes resources to engage expert assistance, the assistance of barristers, and often part of our job is asking very nicely whether some of those other experts and barristers are prepared to act either pro bono or reduced fees. And I assure you we're very grateful when you're able to help out in that respect. Otherwise, most public interest litigation would not proceed at all. We need those lawyers prepared to help out. Otherwise, these cases would not be run. And the last element is timing. All of these different elements of public interest litigation need to come together at the right time before the due date that proceedings need to be lodged. So in summary, I was requested to mention the issue of costs. Costs and resources are very important in terms of whether the community litigant can run the case at all. And the cost rules are very important because they may prove an impenetrable barrier against a very small and poorly resourced community group, which is why one of EDO Queensland's law reform points is always to argue for cost rules that are appropriate for community litigants. You might be aware the Planning and Environment Court cost rules were changed from the own cost rules under the previous government. The new government has committed to restore those own cost rules. So without further ado, I will pass to our chair for this evening, retired Supreme Court Judge Alan Wilson, who will conduct the event tonight.
Thank you very much, Jo, and good evening and welcome to this debate, in which we'll explore one aspect of what sometimes seems to be a never-ending topic. Can what our society traditionally calls progress, that is to say, apparent increases in the material wealth and productivity of our citizens, be achieved in a way which also does minimal damage to the planet that we inhabit? It's a very, very big topic. There are social, economic and intergenerational issues at play. We have to think about not just our bit of the earth, but also, as equity dictates, other inhabitants of it elsewhere, and of course our descendants. We all agree that it's very important. For Queenslanders, these big questions tend to involve big things. We are a very large state. Our natural environment is wonderfully diverse, running the full pantheon from deserts to rainforests. It also contains minerals, which when extracted can leave large indentations in that environment and which, when used, have the potential to do harm to the planet. It's a polarising subject, and we will focus tonight on one important facet of it. The subject, litigating the environment, raises pretty fundamental issues around who ought to be able to use the legal system and the courts to challenge decisions made by government and those associated with typically large enterprises which involve environmental issues, and to what extent. The public debate around that question has been polarising and generated strong tensions and strong words, particularly in recent times. Those who voice any opposition or hesitation about the benefits, for example, of extracting minerals, were recently labelled as green vigilantes and saboteurs by the immediate former Prime Minister. The Attorney General called it lawfare and a red carpet for vigilante litigation. Those who support more mining run the risk of being painted as brutish, insensitive and selfish. But the invective is apolitical. A former Labor Treasurer, Wayne Swan, called a campaign to delay new mines in the Galilee Basin reprehensible and puerile, and said that the coal industry was a very important wealth generator and a driver of jobs. We have all heard these things quite a lot. At times, they have become, you might agree, a little tiresome. The debate seems to bog down in polarised positions when, as a moment's reflection confirms, it has all the facets and complexities which beset every big question. There's a nice word, eschatology. Some of you will know it. It means the great things. It means eternity, damnation, heaven, hell, and the like. It is not, I think, inappropriate or pretentious to talk about this debate as an element of the eschatology of our physical world, this remarkable place that we inhabit. The debate about big religious things has been going on for millennia now, but that around the safe preservation, the sustenance of the earth, is much newer. But it's already clear that we must strive to do better in that debate because whether those who are most worried about the present state of things are right or not, and whether the time in which we might reduce whatever harm we are doing is truly quite short. It is by the dialectic process that we have our best hope of solutions which are acceptable to the majority, because simply we live in a democratic society and, generally speaking, it's the majority view that will prevail. Tonight we take a small step in that process of refining that debate, nuancing it, as it were. We are fortunate to have two eminent advocates to address these questions. A belief in the adversarial system is intrinsic to most of us, and Damian Clothier and Stuart Keim are acknowledged masters of it. Damian is an experienced and highly sought-after commercial lawyer. Stephen has a diverse and interesting practice in areas like environmental law and criminal law. But those terse phrases, commercial lawyer and environmental lawyer, tend to have the same regrettable polarising effect as the invective which sometimes permeates the debate. Both these lawyers are, of course, thoughtful and caring people, as well as lawyers and advocates. Each has, as we all have, pondered from time to time on the big questions, the eschatological questions about the environment. And they are also, of course, in an ideal position to reflect upon the worth of litigation about it. Who are the necessary or desirable parties, and how that litigation has its highest and best use. In the nature of a debate, each has, in effect, accepted a brief. In the nature of legal practice and the cab rank rule, it would be quite wrong to assume that their past experience as advocates or any list of their past clients must be a watertight indication of their personal or individual beliefs or where they actually stand on these questions. For that reason, I ask you to afford them the traditional courtesy that we judges extend to all lawyers appearing before us. That is, of assuming they don't believe a word of what they're saying. I joke, of course. The point is that this is an intellectual, not an emotional exercise. We have asked Stephen and Damian to apply their considerable intellectual and advocacy skills to the brief each of them has accepted. They do so gratis, and we are extremely grateful. Once they have spoken, there will be an opportunity for each of them to reply briefly to the other, and also for questions and discussion with you. We have tossed a coin, and Stephen won, and will speak first. Please welcome Stephen Keim.
Thanks, Alan, and welcome everybody. I also would like to acknowledge the traditional owners of the land on which we stand. When Alan was urging you to give Damian and me the traditional courtesies, I thought he was about to say that you should interrupt us as often as you can without allowing us to get a sentence out. That's the traditional courtesy that we're often used to, but we love it anyway. I'll talk mainly about the topic of standing, the right to bring litigation, because I think that is often at the heart of the debate as to the worth or otherwise of the ability of ordinary people to litigate the environment. Can I start by talking about what I'll call the current furor? In early August 2015, the Federal Court of Australia set aside a decision by the Federal Minister for the Environment which approved a proposal to open a large coal mine, a Carmichael mine, in the Galilee Basin in Western Queensland. The basis for the action before the court and the action of the court in setting it aside was that the Federal Minister for the Environment had failed to consider properly advice that had been provided to him about the potential effect of the mine on two threatened species of animals, the yakka skink and the ornamental snake. If, as many people I know did. In the light of subsequent events, you went onto the legal database Ostly to find the carefully phrased reasons of the learned trial judge, you would have been disappointed. The judge's decision was a consent order. All parties, the minister, the mining company and the Mackay Conservation Group, which was the applicant, the Mackay Conservation Group is not like the other MCG. It's in fact a peak environmental group for the Mackay region. But each of the parties agreed that the correct decision of the court was to set aside the minister's decision and to send the matter back to the minister for reconsideration in accordance with the law laid down in the EPBC Act, the Commonwealth environmental legislation that deals with decisions with regard to matters of national environmental significance. I found it surprising that a successful application for judicial review of a minister's decision, especially one that was obtained by consent, which each of the parties agreed with, therefore, as being the right one, led to the furore that this one led to. The then Prime Minister, Mr Abbott, declared himself frustrated. He said on the one hand that the Carmichael mine was too important to be hindered by red tape, although he said it was important that such projects have to be got right and that they should be let go ahead once they are fully complying with high environmental standards. He also said it was absolutely true that people have a right to go to court. His Attorney-General, who remains the Attorney-General, Senator George Brandis, called on Parliament to end what he called legal sabotage. He spoke of lawfare, as Alan indicated. He described Section 487(2) of the EPBC Act as permitting virtually anyone who had taken part in conservation or research into the environment at any time in the past 2 years to have legal standing to challenge determinations made under the Act. And that's almost what the section says. He said that provided a red carpet for vigilante legislation. Senator Brandis has introduced to the Parliament the EPBC Amendment Standing Bill. That was referred on the 20th of August 2015 to the Environment and Communications Committee of the Senate for inquiry and report, and that committee is due to report on Monday the 12th of October 2015, so that's next Monday. The bill contains one provision. It deletes Section 487 from the Act. So on the basis of what was an eminently successful challenge to the Minister's compliance with Commonwealth environmental laws, brought by a Queensland environmental group, and I think Abbott Point, where Abbott Point is it's near Bowen, so it's about halfway between Mackay and Townsville. I think arguably at least it falls within the Mackay region, and therefore the MCG, which is a peak environmental group for the Mackay region, probably legitimately can claim Abbott Point, the port for the mine, as being within its bailiwick, within its neighbourhood. It was not only a successful application, I'm saying, but it wasn't an application by somebody in the south of Tasmania complaining about something in the north of Cape York. Anyway, that bill deletes Section 487 completely from the Act so that any free right to standing, free right to bring litigation for conservation groups and conservation individuals and researchers into the environment, it will disappear from the legislation if it's passed. Whether that happens or not will depend on what the committee says, I think, to a large degree. Will depend on what the new Prime Minister thinks about that litigation and the leadership he provides to his parties, and it will also depend on what the opposition parties in the Senate, including the crossbenchers, think about it. So that's the furor. That's how it suddenly became a topical issue, this issue of standing. I suppose you can divide standing into two areas. There's common law standing, which I'll talk about in a moment, But there's also the special standing that various bits of legislation give various people. Most people in this room, at least, would be familiar with the way in which local government planning decisions are made subject to litigation in this state. There's all the code-assessable, I'm not even sure that I'm using up-to-date terminology, but the principles are the same. There's all the code-assessable developments. They're the sorts of things which the planning scheme says you probably can do it if you do it correctly, and you can't object to those kinds of decisions. You can still litigate them in the Planning and Environment Court, but it's much harder to find something to say about them that would provide a proper basis for litigation. And then there's all the impact assessable developments where the planning scheme says, I'm not quite sure that this sort of thing should go here. And so the onus is really on the developer to establish that it should go there. And everybody, even if you do live in the south of Tasmania, has a right to object to that, and if you've objected to it, you can go to the Planning and Environment Court and you can bring a merits appeal. That is, you can bring all your experts along to court and you can argue that the council's decision is not only procedurally wrong, not only that it failed to comply exactly with the legislation, but you can argue that it got it wrong anyway at the end of the day. It's the wrong decision on the merits. The same sort of rights have traditionally applied with regard to mining leases, application for mining leases, like little mines and big mines like those in the Galilee Basin. Again, there's a requirement to advertise. People can file objections, and if you file an objection, you've got a right to go to the Land Court. And again, bring all your experts along, argue it on the merits, and the Land Court makes a recommendation. The Land Court doesn't make a final decision, and that goes to the Minister, and the Minister makes the final decision. Common law planning rights, and this is what will happen with regard to the EPBC Act if Section 487 is deleted. There was a case in 1979 called ACF in the Commonwealth. I know it well because I've argued many cases on standing, common law standing in the courts, and I've won some and I've lost a lot. And they've taken up a lot of court time and a lot of resources. But what ACF in the Commonwealth said was you have standing if you have a special interest in the subject matter of the action. And so if you are a local conservation group and you've walked people through the local council reserve and you've sold T-shirts based on it and you've made a little bit of money out of it by taking people, you might have standing, but then again you might not. And that's why it takes a lot of time to litigate those matters, and that's why you're never quite sure of the result. I went to the High Court and back with regard to some mines in Mount Etna, which were the environment in which the ghost bat lived. And it was proposed that they would be blown up by the local cement company. I went to the High Court and back, and I still don't know whether the local caving group in Rockhampton had standing with regard to that because the High Court decided not to decide it. Anyway, years later, after blowing up one of the mines, the cement company or whoever owned it, these 2 decades later, decided to hand all the other caves in which the ghost bat lived over to a public trust so that they could be public trust land. So something happened even though I didn't find out what standing was. But that's how common law standing works, and it does take up court time, it is problematical, and it stops a lot of ordinary people from contesting the legality of government decisions under various pieces of legislation. Why is it important? Well, I put it this way, I don't think you can find any politician who doesn't support ecologically sustainable development. That is, development which looks after future generations, which is sustainable in the long term. And that's why we have a lot of environmental legislation. We have legislation so that government decision makers who are making decisions with a whole lot of with regard to a whole lot of development proposals. They might be a drive-in picture theatre in the suburbs. They might be a tourist resort on the coast or in the mountains, or they might be some kind of oil refinery, or they might be some kind of mine, some iron ore mine, some coal mine, a salt mine, whatever. The legislation lays down these principles of ecological sustainable development that have to be taken into account in making those decisions. They require things like the preparation and then the assessment of things called environmental impact assessments, so that all of those things which are required to be considered by legislation by the decision maker, there are studies done into those and information provided with regard to those things. And because development and because the environment are both complex matters, then there are a lot of procedures to be followed to make sure that the decisions at the end of the day are right for everybody, that they follow the principles of ecological sustainable development. Now, that means that public servants have to work very hard. It means that decision makers have to work very hard. Now, if you're a public servant assessing these proposals, if you're a minister who's making these decisions, then if you know that if you get it wrong, if you get lazy, if you muck it up, you can be taken to court, and a court will look at what you did and assess whether you did it correctly, then you'll be very, very careful. If it's quite unlikely that you'll ever be taken to court, then over years and over generations, you as a public servant and you as a decision maker are likely to get a lot more lazy and a lot less careful about the extent to which you follow the rules which are laid down in legislation, which, as I say, are generally rules intended to promote ecologically sustainable development. So that's why I think it's very important that ordinary people can bring these challenges to the court, so that our environmental legislation, which everyone supports, does not become some kind of dead letter. And what we've seen with regard to the EPBC Act, which became law in about 2000, is that there have been a consistent number of applications, whether it's, well, there's been a lot of applications for approvals. Applications to the court are probably less than 50. A number of them have been successful, a number of them haven't. One particular matter that I was involved in involved the Nathan Dam in Queensland. And in that case, the question was whether Section 75 of the Act required the minister to take into account, which we called both literally and metaphorically, downstream effects. The proposal was to build a mine. The mine was to allow farming with the water. It's not a mine, a dam. The dam was to allow farming to take place with the water that the dam stored up. The farmers, we said, were going to use fertiliser, and that fertiliser had a potential impact on the Great Barrier Reef, which was hundreds of kilometres downstream. And so the conservation group, for which I was acting, argued to the minister that you, Minister, should take into account and consider whether this dam should be built in the light of the potential effects of the farming and the fertiliser on the Great Barrier Reef. The minister said, I'm not allowed to take those effects into account. I only can take into account the immediate effects on the environment, even though the phrase said all adverse impacts. I can only take into account the detrimental effects of the mine itself, building the mine itself and the water that it stores up, etc. We went to court. We went before Justice Kiefel, who was then a judge of the federal court. Justice Kiefel wisely agreed with our argument and said the minister had to take those into account. The minister wasn't absolutely satisfied with regard to the question and went to the full federal court, and the full federal court said that we were right, that Justice Kiefel were right. And that case is probably about 10 or 15 years old now. And I say it's a good example. It's a good example for me anyway, because if that case hadn't been successful, then it probably would have been the case that every consideration of every proposal after that would have not been in accordance with the requirements of Section 75 of the EPBC Act. That is, to the extent that Parliament intended, by writing Section 75, that all adverse impacts, including downstream effects, must be taken into account, if that litigation hadn't been brought, then they wouldn't have been taken into account, so that we would have had, in that respect at least, the EPBC Act as a dead letter. And so that indicates to me how important it is for some ordinary individual who has some wild idea that the minister has got it wrong to be able to bring that litigation and test those issues, and in that way our decision makers and our public servants who are assisting them apply the law properly. It keeps them on their toes so that they're conscious of applying the law properly, and it makes sure that our environmental legislation, which, as I say, we all support the idea of ecologically sustainable development, which is written into our legal rules, is actually carried into effect. And I suppose the only other thing I would say is that you would think that after a lot of thought had been given to the matter, and this legislation, including Section 487, was passed into effect only 15 years ago in 1999, that perhaps that was a hard-won battle and that would determine the status quo for many years to come. But now we have an Act changing that crucial aspect of the law with regard to standing. And all of us, I think, treasure the fact that if somebody tries to build a block of flats next door to us, we can go to court and argue that they're not entitled to do it. But if Section 487 can be stripped away, as it may well be stripped away over the next few weeks and months, then maybe our right to go to the Planning and Environment Court is not quite as secure as we thought it was. Thank you very much.
Thank you very much, Stephen, for that enlightening talk. We are now going to hear from our other speaker this evening, and I ask you to welcome Mr. Damian Clothier QC.
All right, thank you, and thank you to the EDO for inviting me here tonight. I'm going to address you this evening from the perspective of a lawyer who often peers for clients who appear against the clients of the EDO, that in environmental litigation, that is, from the perspective of a lawyer who often appears on behalf of large resource companies in relation to large resource projects, and hopefully give you some perspective on some of the matters discussed tonight from that viewpoint. I particularly propose to address you on two matters that in my experience represent significant challenges in relation to public interest environmental litigation. The first matter relates to some aspects of current environmental approvals processes, which often end up in litigation, which are often the catalysts for public interest environmental litigation, which seem to me to have some undesirable consequences that the environmental issues litigated before the courts in that type of litigation are not identified and supported by evidence well in advance of the matters proceeding through the courts. It's sometimes the case, in my experience at least, that environmental concerns, very legitimate environmental concerns, and the evidence in support of them are not fully identified or addressed until a very late stage in the process. And in my view, that's not particularly desirable, not merely from the perspective of proponents, but from the public interest. And I'll discuss some ways in which I think that issue might be addressed. The second aspect that I'm going to address is related to the aspect that Stephen's addressed and touches upon the issue of standing. Can I say that I share his view immediately that it's a strange catalyst to have a debate about amendments to the EPBC Act, that there was a litigant who was successful in persuading the minister that the minister had got the decision wrong, with the result that the court was approached for a consent order to set aside the decision. But the debate about standing isn't new. It's been going on for a long time, and that probably reflects the fact that the standing rules are quite a mess, are difficult for lawyers to understand, and are probably impossible for members of the public to understand in any particular way. What I propose to discuss tonight is, from a lawyer's perspective, the possible need for reform in that area, not to remove standing from environmental organisations and the like, or from community organisations for that matter, but rather to provide a set of rules which everyone, proponents, the public and those organisations, can understand and apply without the current confused mess. Can I deal with the first matter, which was the early identification of issues and the provision of information in relation to them? Not everyone here is a lawyer, I'm sure, but those who are would be familiar with the desire of courts in litigation to have the parties identify and address at a very early stage what are considered to be the real issues, the important issues in dispute in the case, the important issues that need to be decided. And in the courts, a lot of procedural, organisational and cultural reform has occurred, particularly over the last couple of decades, and it has enabled those types of issues to be identified fairly early on and then to be dealt with effectively and efficiently. Now, that's a desirable goal, but it's also a desirable goal, in my view, in respect of processes that occur before environmental matters get to the courts. The courts recognise that goal as desirable for a number of reasons, but particularly because, to use lawyers' terminology, the early identification of and just and expeditious resolution of the real issues in dispute is understood to be both in the public interest and in the interest of particular litigants. The efficient identification and resolution of the real issues and the just and expeditious resolution of the real issues saves public and private resources, including time and money, and promotes confidence, I think, amongst the public that the right balance is struck between the capacity of a person to have access to the courts to air a legitimate complaint and the rights of those who are brought to court to get on with their personal lives or their businesses or their professions with just expedition. That same goal, recognised by the courts when the matter gets before them, is, in my view, a desirable one which is applicable to the processes that apply before you get to court. From a proponent's perspective, time's money, as you often would hear, but resources are also very precious, I think, to environmental organisations, environmental litigators, and to community litigators, particularly in an environment such as we have now, where funding for that type of public interest litigation is in short supply from governments, and litigators have to rely either on their own resources or on the resources provided by the generosity of the public in order to commence litigation. But unfortunately, in my view, the achievements of the courts in reforming their processes aren't matched by the pre-litigation processes, those processes being precursors to litigation often, and processes which often shape what comes before the court and the issues. Can I give you an example? And the example relates to large mines. And Stephen has touched on some of the processes that relate to the assessment of large mines in this state, but I'll say something more about it if I might. Many of you would know, but some of you may not, that a mine requires a great many approvals, as is appropriate. Particularly though, a mine requires a mining lease under the Mineral Resources Act, and it requires an environmental authority under the Environmental Protection Act. In the case of particularly large projects, such as those projects proposed for the Galilee Basin, the so-called mega mines, projects are often also declared to be projects of state significance under the State Development and Public Works Organisation Act, a piece of legislation, I think, fairly peculiar to Queensland. The results of those pieces of legislation is that the proposal would proceed through a very substantial environmental impact assessment process involving the generation of an enormous amount of paper and voluminous multidisciplinary resorts, a great deal of expenditure by proponents and by those who are interested in responding to proponents' proposals, will involve a lot of time and a lot of effort. And the final outcome of that EIS process is intended to be, for very large projects, the generation of a report called the Coordinator General's Report, which may approve or disapprove a project, and in the case of an approved project, may impose or recommend conditions which are often conditions directed towards, in the Coordinator General's view, mitigating environmental impacts or eliminating environmental impacts. That process is supposed to consider most, if not all, of the aspects of approvals required for the project, including the mining lease, which is essential, and the environmental authority, which is also essential. Now, in that process, the Coordinator General's process, there's the opportunity for individuals and organisations to have input, but in practice, I think the input is really quite limited and not particularly effective. Submissions are often invited, but generally, the submissions which are attracted and the information upon which they're based don't generate the extent of detail or thought, or are not supported by the extent of information which you might see or expect if a matter were then to proceed through a court. And if there's a conflict between what, for example, a submitter or an objector provides to the Coordinator General and what the proponent provides, then there's no particularly rigorous way for that to be tested or resolved. Now, following the conclusion of that Coordinator General's report, in the example I've given, it's often then the case that after there's been what a proponent would regard at least as a very extensive and time-consuming assessment process, the mining lease application is advertised for objections and the draft environmental authority is issued, and again it's advertised for objections. And as I think Stephen indicated, anyone can lodge an objection. There is no interest requirement associated with doing so. And if an objection is lodged or objections are lodged, the matter then proceeds to a hearing in the Land Court. And I'll come back to that process in a little bit more detail in relation to the second topic. Now, very understandably, the Land Court and the litigants before it, and particularly the environmental and community-based litigants before it, view the Land Court process as a very important one because it's a process that often involves a contested hearing before an independent tribunal to consider and address issues relating to the mining lease application or the environmental authority, including the potential impacts on the environment at a local, state, national and sometimes even international level, for example, if we're discussing climate change. So in a sense, there are two processes which might be thought to cover, in large degree, the same area. They are not the same process, and the court process, I'm sure, many would consider to be more rigorous because it gives litigants the opportunity to test the evidence upon which the proponent's proposal is based, whereas the earlier process does not. Now, there's no doubt, I would have thought, just having regard to public statements by some of them, that some proponents of resources projects would wish to see there be no court process and wish to see that the Coordinator General process is the end of it, or at least see the court process curtailed, and there have in fact been moves to curtail in some respects that process. Now, that's not an expression of my personal view, it's an expression of the view of some in that particular industry. But I can understand in a sense, not the ultimate view that that process should be curtailed, but some of the things which are of concern which lead to that view. One of those things is the way in which that dual process can mean that issues and information in relation to issues only emerge at a quite late stage in the course of the Land Court hearing or the Land Court process. That's not necessarily anyone's fault, it's certainly not the court's fault. And typically it's not the fault of the proponent and it's certainly not the fault of the objector. It's simply the consequence of the way in which things work. So, for example, if it's entirely possible for a project to proceed through a Coordinator General's process involving a lot of expenditure of time and money on the basis that certain issues are the issues to be discussed and considered, and on the basis of the information that addresses those particular issues. but for the court process to proceed on the basis of an objection which either raises a different issue or substantial and important, often, information in relation to an already identified issue. And it's that which seems to me to be a very undesirable thing, that is, that the issues and that the information in relation to the issues aren't identified earlier. Because if they are identified earlier, then I suppose in a perfect world they might be addressed earlier. And there would, I think, be less complaint, particularly amongst the proponents, about the way in which the dual processes work. Proponents would consider that they think it's undesirable, that they've invested a lot of time and money, for example, to address the impacts of their projects and respond to concerns, only to have to duplicate or revisit matters later on. I think, without suggesting that they would necessarily, all of them at least, want to change fundamentally the process, simply to have a single mechanism to get the issues out and to get the evidence out and to get the issues and the evidence considered in a more efficient way, I think would be of benefit to them. But I also think it's in the broader public interest to be desirable that objections and information in relation to objections be provided comprehensively before the coordinated general stage, because then the public will have greater confidence, and I think sometimes the public doesn't have confidence in relation to that process and sees it as bureaucratic. But if the issues come out earlier, I think the public will have greater confidence, or can have greater confidence, that the process is thorough. And when the matter proceeds to court, as it no doubt still should, if the issues aren't resolved, when the matter proceeds to court, the issues will already have been identified, they'll have been addressed in large part, there won't be any surprises, there won't be any further delay caused by the way that the regime currently works, which involves, in effect, a fresh reconsideration of everything at the second stage. Now, that doesn't involve the court's important independent role as a tribunal to test some of the evidence to change. But it does seem to me to be undesirable that pre-court processes don't facilitate the point that by the time the matter comes to court, the issues and the evidence relating to those issues are comprehensively identified already, so that the court process can be conducted more efficiently and more expeditiously. The present regime, I think, can lead to a perception, and it's no doubt an overstated perception at times, but with some validity in my view, that important aspects of the pre-court processes are set at naught. Now, no process is actually going to negate that perception entirely, but I do see the failure of the pre-court processes to comprehensively identify objections and grounds of objections and evidence in relation to objections as being something which needs to be addressed. And it impacts, I think, not only proponents, but I hope I attempt to look at things from both sides, because it also, in my view, impacts those environmental groups and community groups and individuals who seek to challenge the earlier decision-making processes. Whatever the merits of the particular objection, and there are objections, as one would expect, that have very good merit on environmental and other grounds, and are treated very seriously both by proponents and courts alike. But whatever the merits of those objections, the process can cause delay and duplication of effort, and a greater and earlier focus on legitimate grounds of opposition and the evidence of support of them would seem to me to be not only in the public interest, in the proponent's interest, but also in the interests of those who wish, nonetheless, to conduct environmental litigation to test the proponent's proposals. Now, I'll turn next to the question of standing, not to discuss the current regimes in any great detail or to discuss any current proposal to change issues of standing, but to discuss it from the perspective of a lawyer in relation to projects in Queensland which are of significance to the environment. Now, from that perspective, lawyers generally strive to see that there is some coherence in the law They don't do that just because they're unnecessarily technically focused upon coherence, but they do it because they think that the public likes to understand and see that their law is coherent and comprehensible. The problem with standing, it seems to me at the moment, is that if lawyers can't understand the complex and different rules that apply depending upon the particular regime you're working under, then the public can't possibly hope to do it either. And the public can't possibly hope to have confidence in that regime. Standing is one of the true barriers of entry for public interest environmental litigation, and therefore it's one of the true challenges for it. There have been many reports over the years from law reform and other similar bodies which have identified what I suggest is a lack of coherence regarding standing rules, and which have questioned whether they do more harm than good. And I can understand the basis of that questioning. Stephen's already indicated to you that he's spent a lot of time in court debating issues of standing. That time spent is time which may have been spent not debating issues of standing, but debating the merits of the relevant environmental complaint. There have been various legislative attempts to reform standing issues in relation to particular matters. Those attempts, I think, are very clunky. Taking again large projects in Queensland, for example, as Stephen's indicated, one has a process by which objections to mining leases and environmental authorities can be lodged by anyone, that is an open standing requirement under relevant legislation, which might lead to a full hearing on the merits before the Land Court of the relevant environmental concerns. One contrasts that with different aspects of processes, including aspects under the Commonwealth legislation and aspects under other state legislation, where there is no such right to lodge an objection, where there is no such right to proceed to a hearing on the merits, where litigants are often confined to challenging decisions after they're made, and then only on legal grounds, not on merit grounds, but on legal grounds, and then having to confront the notion that they're not considered to be sufficiently interested in a legal sense to be able to bring the relevant proceeding. Now, the difficulty, or a difficulty in relation to that, is that often similar types of projects are the subject of different types of rules. Or often, different types of stages or approvals processes in relation to the same types of projects are again the subject of different types of rules. And that feature in particular seems to me to be entirely unsatisfactory. As I said before, I would regard most lawyers as finding it difficult to understand and justify why there isn't that coherence in relation to what, in substance, are approvals processes involving the same types of issues in relation to the same types of projects. And if lawyers can't understand how that works, then I doubt very much that the public could either. So that's an area where it seems to me there is a need for reform. That reform doesn't have to involve going back to the bad old days in a sense where standing was denied to people with legitimate environmental and community interests. Nor does it have to involve stripping any standing requirements at all from environmental litigation, as is often the case in these types of issues. It will probably involve some middle ground approach. An example of that attempt at a middle ground approach is identified in the EPBC Act that Stephen's already referred to, and that is that there is in effect a statutory standing given to organisations and individuals that can prove a legitimate track record of interest in relation to environmental issues, even though that legitimate track record wouldn't satisfy a legal test at common law for standing. So rather than necessarily debate whether existing standing requirements ought to be watered down or eliminated from important legislation, I would rather see a more general reform which sees a coherent set of rules commonly applied so as to facilitate environmental public interest litigation, as between the Commonwealth and the states, and as between various projects, so that not only the lawyers involved but also the public can know and understand and have confidence that technicalities are not being taken in relation to environmental challenges, that the merits are being got to, and that these types of issues are not being used as a distraction from litigating legitimate environmental concerns. Thank you very much.
Thank you very much, Damian. We've invited each of our speakers to take the traditional lawyer's opportunity of exercising a right of reply, which they'll do briefly, and Stephen will go first.
There's not a lot that Damian has said that I have real difficulties with, and to the extent that I have some questions, there are probably people in the audience who are better equipped and more knowledgeable to traverse them. I would just say two things. First, with regard to the involvement of the Coordinator General and then the process of applying for the mining lease and going through the land court. One of the issues that often arise in many different types of decision making is that environmental impact statements have been produced over a lengthy period of time. They're very voluminous. The opportunity to comment on them is often extraordinarily brief, and as a result of that, it's difficult to identify which issues have been looked at in depth and have been properly dealt with and which ones have been skated over. And so, without a lot of knowledge of the State Public Works and Everything Else Act, I think I probably would agree with the proposition that a Coordinator General could probably serve a very good process in managing, or could perform a very good role in managing the EIS process so that the public can have an opportunity to input into that process at a legitimately early stage, so that by the time one's looking at the final notice for objectors, we really do have a properly in-depth and well understood environmental impact statement for the particular proposal. With regard to standing, I probably just say two things. One is Section 487 of the EPBC Act is really intended to achieve exactly what Damian is talking about, and there's no magic in its wording. You can make it more rigorous or less rigorous. It would still enable people who have a real interest in the subject matter of the litigation to actually show that they've got that interest and be entitled to bring litigation. But there are also some social and historical considerations associated with, for example, the ability to object to a proposal under the local planning scheme. There would be real social ramifications if we said, well, you have to have a track record with regard to tree planting in your local neighbourhood to be able to object to the local picture theatre that they're trying to put up there. So some of the rules, which are not as logical as they might be, have historical and social explanations, and I think that has to be factored in. And the last thing I wanted to say is that when Damian says that the courts have very good processes to develop and identify issues and find common ground where it can be found, that in one sense is an understatement, because I think it was mainly pioneered by the Planning and Environment Court, certainly subsequently taken up by the Land Court, although Judge Jones might have some different view with regard to the history there, and also adopted by the Supreme and District Courts as well. The processes by which mediation and identifying the issues and case management is conducted by the Planning and Environment Court, and as I say, taken up by other courts, is actually world's best practice, and it is extraordinary, and it's a tribute to those judges and other officials and also the litigants in those areas for developing those over the years. So I think probably a lot of decision-making areas have a lot to learn from those processes. Thank you.
Thank you, Stephen. Damian will now exercise his right.
Which again will be very brief, because there's not much that we disagree upon, I think. The notion that there ought to be legislation which is toothless in a practical sense because there is nobody who can enforce it is fairly unattractive to a lawyer. And I agree with Stephen that in relation to environmental legislation, some relaxation of standing requirements is often appropriate, because absent that relaxation, there is unlikely to be anyone to effectively take on or challenge decision-making. And taking on and challenging decision-making is often a very good catalyst for improving decision-making. It's unlikely, for example, that a minister of the state or Commonwealth who is tasked to make a decision under environmental legislation would make that decision, and that then some emanation of the same state or Commonwealth would seek to challenge it. It's possible, particularly if that emanation is an independent organisation, but if not, it is unlikely. That leaves you in the position where, for the most part, in relation to a great deal of decision-making, the legislation may contain requirements for the lawfulness of the decision, but there is, in a practical sense, no one to enforce them. Now, the solution for that conundrum hasn't been found yet. And unless the state and the Commonwealth propose a solution which sees some other body, for example, take on the task of reviewing and challenging decision-making at that level where appropriate, then the reality is that in the modern age it often is left to individuals, or is left to community groups, or is left to environmental groups. Where does that leave us? I think personally that an open standing requirement, that is a requirement in relation to the types of projects I was talking about, that anyone should be able to make a challenge or lodge an objection, is going perhaps a little bit too far. But equally, those who can legitimately demonstrate that they have some kind of track record or some immediate concern, even though it's a concern that the law doesn't really recognise presently as being a sufficient legal concern, ought to be able to challenge and therefore promote good decision-making. If that doesn't happen, and I don't know the status of the current legislation, but you would expect that under the EPBC Act, it would be legislation that it might be very difficult to get through the Senate. But hypothetically, if that type of legislation were to get through the Senate, or similar legislation were to get through state legislatures in relation to standing rules that have been entrenched for some time now and have become part of the public psyche, then one might expect that the High Court, if the legislature doesn't reform, that the High Court would perhaps take the opportunity in the future to engage in some reform of its own and relax the standing rules, which are often, as I said before, the source of a lot of technical legal argument, which is productive of waste, which is productive of a diversion of resources from what are the real issues in the case. Thank you.
Thank you, Damian and Stephen. We have some time now for questions, comment and further discussion. And I'm going to throw the floor open, as it were, to questions of either or both of Stephen or Damian. There are some roving microphones. Please signify by raising your hand if you would like to ask a question and to whom it is directed.
Good evening, David. Thank you for your speech. It was quite interesting. Just wanted to comment on the standing about people having an interest and long-term, they've had some interest in expertise in the area. Would you say 2 years experience for a community group would be sufficient? Because my understanding, I haven't been doing environmental for a while now. My understanding of the EDO Qld Act was it was 2 years for a conservation group. Someone else might be able to correct me there. If that's the existing law as it is, I'm not quite sure what you're getting at about reform of the standing. Because to me, the standing, if it is the 2 years of community groups, is actually quite appropriate, and in fact might be less than what is needed, because perhaps someone who has a year, or even less than that, maybe a month, might be quite good. And people who have expertise, for instance, of 2 years in hydrology, or several, or perhaps a graduate from university, would they fit into standing? I'd just like some feedback on that, and what you're thinking about. How would you form an interest and concern in the environment?
It is, I think, 2 years under the Commonwealth legislation. My point wasn't so much to propose what the requirement should be, but to propose that the requirement should be consistent across all jurisdictions. The problem at the moment is that, yes, there is a 2-year period of concern and interest, which gives you sufficient standing under the Commonwealth legislation. There are different rules applicable to state legislation. And even under the Commonwealth legislation, that 2-year period of standing only relates to challenging, I think, under the Commonwealth Judicial Review Act, which in turn is limited to challenging on legal grounds. Contrast that with some aspects of state law where you can, in effect, involve yourself in a full merits review with no interest whatsoever. I personally, and this is a personal view, it's not the view of any clients, I personally think that if you demonstrated 2 years of a proven track record in relation to environmental community issues, then that ought to be enough. My point, though, is to suggest that rather than focus upon diminishing or eliminating standing rights, there should be a focus on reforming them to ensure that they're consistent across the board.
Alan, can I just to show that I'm a pedant, I've got a copy of section 487 here. It's actually a little bit more liberal than the questioner indicated. It's at any time in the 2 years immediately before the decision, but that's balanced by the requirement that the individual or the organisation has engaged in a series of activities for protection or conservation of or research into the environment. And with regard to organisations, you require not only the series of activities at any time, but your objects also need to reflect that as well. So it's pretty liberal, and the 2 years is really the period within which you have to have done that.
Thank you. I've had a fair bit of experience with standing and in environmental matters, but I was particularly interested in the suggestion of how you resolve an issue before you get to court. And I was interested in the proposition that Damian put, that we should try to find some means by which we've sort of clarified the issues so that they're addressed, or we've got a clear sense of direction when we get to court. The problem is the whole production of the environmental impact statements in Australia, and particularly in Queensland, and there's also this difficult position between the client and the consultant, because the consultant is dependent on the funding from the client. So what they've done in Western Australia is that So there's an arm's length direction, and that way you get far more independent environmental impact statements in the first instance, and it's also a much more open process and something which we can have a bit more faith in than our current processes. But I would like to say that we do need to have matters of standing. If we didn't have standing, if I hadn't had standing, Fraser Island would be a sandmine now.
I understand concerns amongst a lot of people that consultants might be thought to be beholden to the people who retain them. That's not necessarily my experience, I must say. My experience is that consultants certainly try to be vigorously independent. But it is a problem, and it's a problem of perception as much as anything else, and it's important that the process which leads to a Coordinator General's report be seen to be as independent as it can be. Stephen touched upon an earlier matter, and that is that often the period to making submissions and objections is far too short to be able to digest the enormous amounts of material that are involved in the EIS statement, some of which can be 30 volumes. There's no prospect that someone could meaningfully look at that and respond to it within the short periods of time that legislation allow. If you did more work up front, I think, in ensuring that the process is independent, something in which people can have confidence, and that people have a full opportunity to air their grievances earlier, then I think in the long term that will create efficiencies, even if matters still proceed to court.
One of the advantages of allowing the proponent to engage their own consultants is that a project evolves, and often whether it's somebody in the community, somebody in the organisation, somebody in the council, somebody in a government department who raises the issue, who points to the problem, often then a proponent who's been involved in designing the project can actually adapt the project so that it's actually a better project, and a better project from an ESD point of view. So there are advantages in having the proponent's own consultants involved in it. What the Commonwealth, and I assume that this still happens, but what the Commonwealth has done with regard to EPBC Act applications often is to engage its experts to look at studies, for example, by ecologists, get an independent ecologist to look at the proponent's ecological study to in fact see if in fact it's sufficiently rigorous. I think one of the other issues is, to which there's no simple solution, is that there's no degree of study that is sufficient. If you're going to look at the owls in a particular bushland area, you can check them out for 2 nights, or you can check them out for 10 years or 20 years. The 20-year study will be a lot better, but in many regards it's impractical if this proposal is going to be built, this ecological resort is going to be built in the next 4 or 5 years. So what I think consultants and proponents often go for, because there's resource issues involved, is understanding the problem sufficiently so that they are confident that if any issues arise, they can be solved at the design and developmental stage. Whereas people who have concerns about that issue in the community want the issue looked at in more depth. And there's no right answer to that question. But that's the sort of thing that if you do have a good EIS, but not a perfect one, and a proper time for people then to study it and look at it, and perhaps some independent experts engaged by the government department to look at particularly crucial aspects of it, you can get the right degree of complexity, or close enough to right that people can agree that, yes, that's looked at the thing properly.
Certainly the State Planning and Environment Court, Mr Sinclair, and I'm delighted to see Judge Jones here from that court this evening, has for some years used highly successful practices in which the experts in particular disciplines are simply put together and asked to realistically discuss the merits of their competing or differing views, if they do compete or differ. The difference between experts in every other professional field in the world and lawyers is that if you do that with those other experts, they will try and find a solution. And it's worked very well in the Planning and Environment Court. Now, there was another question down here, I think. Yes.
Thank you. Ian Pepper, humble public servant. The question to both speakers, do you think that the litigation in the Land Court for state-significant projects will be assisted by the Coordinator General being involved as a statutory party in addition to or instead of the department?
The problem, I suppose, which is one that commonly arises with joining the decision maker, is that the decision maker is supposed to not turn into an advocate for their decision, but is supposed to be fairly neutral and independent in the process. Just as the statutory party, I think, is neutral in the process in which it's joined, I don't think that joining the Coordinator General, in effect, to justify or to argue in favour of their decision would help. And the problem that I identified earlier also applies, that after the Coordinator General's decision, things have often moved on, because the nature of the process in the Land Court is that there will often be a complaint that there is some issue that's arisen or is addressed by further evidence that actually hasn't been considered fully by the Coordinator General. So I don't presently see that joining the Coordinator General would assist matters much. I think that getting to the point where you've got all the issues out and all the evidence out before the Coordinator General makes their decision would assist more.
There was a question over here. Yes. Yes, Peter.
Peter, more of a comment than a question per se. As a consultant, when we done lots of EISs, and some very, very big ones, including our point, which we spent about $15 million on doing. One of the critical issues is actually getting the terms of reference correct. So if you don't get framed right, which is an issue for the Coordinator General, then you don't actually get the stage right. And that's where your massive gaps start to appear. I do agree that there's consultants that aren't judicious and proper, but the ones that do the work and do it properly and get in terms of reference right at the very front end, you'll get a good EIS.
Thank you, Peter. We'll call it an evening. I know Joe's going to make a couple of closing remarks. I wanted to say one thing about the Environmental Defender's Office, and it's this. When I took over managing the lists in the Planning and Environment Court a long, long time ago now, and I knew nothing of the EDO, one of the first things I learned of it and some other organisations regularly involved in proceedings in that court was the high calibre of the representation that they provided to people with what constantly seemed to be very stretched resources. One of the solutions to the problems that we've been talking about this evening seems to me to be a well-resourced, independent defender of the environment, and the Environmental Defender's Office has fulfilled that office for many years very successfully, and it seems to me vital that it is supported in its efforts to do so. And I was pleased when asked by Joe to play a role tonight to do what little I could to that end. Can I ask you to join with me in appreciating what Stephen and Damian have done for us all tonight, and that is to focus quite intensely upon some particular issues that beset problems that arise in what I'll call this jurisdiction. It's much bigger than just a jurisdiction. It's critical to all our survival and our happy occupation of this planet. Let's thank them.
Thank you very much, Judge Wilson, for chairing this evening. We perhaps would have had more questions if we had a little bit more time. So I would invite everyone who's attended that if you have an idea or a suggestion of how you think public interest in environmental litigation could be improved, whether by looking at the assessment process leading up to the litigation or the litigation itself, send your ideas into Environmental Defenders Queensland. We'll probably put up a Facebook post of some kind and you can make a quick comment, or if you would rather make a more detailed comment, you can email those in. We'd be very pleased to receive them. I know, for example, that Minister Lynham, Minister for Natural Resources and Mines, is interested at improving the environmental impact assessment process. So this is quite a timely occasion to try and think how that might best be improved. Pass your ideas to us and we'll try and synthesise them into an orderly fashion. So in terms of some of the ideas that have come out tonight, I think they are all important ideas that do deserve further consideration. We haven't talked a lot about resourcing. I know in the audience are many community litigants for whom the barrier wasn't legal standing, it was resourcing to pay for experts and barristers and participate, or on some occasions it was adverse cost risks, which as small organisations or individuals that were concerned about their house, they weren't able to take that leap, whereas commercial operators or government are much more willing and ready to go to court to protect their interests. So there's quite a few different issues there in terms of litigation. And I know Dr. Chris McGrath is here in the audience and he's given a lot of thought to some of those other barriers. So in conclusion, I'd like to thank all of you for attending, and especially those of you who've volunteered your time and effort to help EDO Queensland deliver its services, and all the community litigants who I know have put hundreds, if not thousands of hours of their time as volunteers on public interest issues. But in particular tonight, I really would like to thank retired Supreme Court Judge Alan Wilson for taking the effort and the time to chair this evening. Could you please put your hands together for Judge Wilson? I'd also like to express my thanks to Stephen Keim SC. For those of you that don't know, SC stands sort of for QC, but it's a more independent mark, I think, there. But Stephen has certainly, over many years, stood up and done a lot of volunteer work and contributed ideas and suggestions that are very, very valuable in public interest environmental law. So thank you so much, Stephen. And I would also really like to thank Damian Clothier. I think it's really valuable in these sorts of debates and discussions to have a variety of perspectives. So Damian clearly spent some time thinking through what could be valuable improvements, and we really appreciate you spending the time and coming along tonight to spend time with the community litigants, Damian. So I have here some small tokens to give to our speakers. I'd also like those of you that aren't familiar with Environmental Defenders Queensland, maybe you'd like to pick up one of our leaflets that's here that has a little bit about our work. There's some here or there'll be some out the back. But once again, thank you so much for attending, and I'll just pass these small tokens to our speakers and our MC.